If you remember last meeting, we went into the different introductions to the various books of the Code of Canon Law. So after we've done the whole book one, which is general norms, I gave you introductions already to book two, which is people of God. And people of God has three parts. And that's important because when you look at the Code of Canon Law of 1983, that exactly fulfills the ecclesiological paradigm of churches, people of God in Vatican II. So part one begins with Christ faithful before the hierarchical constitution of the church. And part two is the hierarchy, and part three, the institutes of consecrated life and societies of apostolic life. So that is very important in your own understanding of the Code of Canon Law as revised through Vatican Council II documents. And then we went into the teaching office of the church. So when you again look at it, this teaching office, this people of God, the sanctifying office, they fulfill what we've all received at the baptismal consecration, the threefold office of Christ received by every baptized, it being priestly, kingly, and prophetic. So teaching office of the church, everything that has to do with teaching. And we went into the different elements there: preaching, catechetical formation, missionary activity of the church, Catholic education, and means of communication, and then profession of faith. We highlighted the fact that when you look at means of social communications, there is the regulations. So everything is regulated. And when you say regulated, we saw two Latin words there: imprimatur and nihil obstat. And then we went into the sanctifying office of the church, and that's where we begin today. Talk of the sanctifying office of the church. Everything that has to do with the means to sanctify every Christian, and that's through the sacraments and through the sacramentals. By way of making a distinction between sacraments, I will just have to plainly say what how canon law would look at it. The sacraments are those instituted by Christ, and the sacramentals as instituted by the church. So you have the seven sacraments there. Now, what does canon law treat in this book on the sanctifying office of the church is, of course, very different from what you have in the liturgical books. Liturgical books contain rubrics. And of course, rubrics also have something to say about liturgical laws. So in the sacraments, as in the Code of Canon Law, what you have there are certain points, of course, like it gives you an introduction to the sacrament, and then it gives you the pastoral care of the sacrament, the minister of the sacrament, and all other elements pertaining to that. In marriage, for example, which is another course, Canon Law 3, there are lots of things that need to be outlined. There are more detailed elements in the celebration of the sacrament. That's precisely why you have it as a course itself, because the whole life of the parish pertains to family life, how we have to take care of the families, but especially couples. And then after the sacraments, you have the other acts of divine worship, and so that's where you have to put in the element of the sacramentals and all other items there, like liturgy of the hours, funerals, veneration of saints, sacred images and relics, and vows and oaths. So these are like part of the generic title of sacramentals. And it's important also to go through them because, for example, when you enter into the code on funerals, what is church funeral? There's only one canon there, but it exactly says what it is. Christ's faithful who have died are to be given a church funeral according to the norms of law. And probably in your discussions here or in the pastoral questions, you will be asked, like, what happens when a person commits suicide? Shall he be allowed or shall she be allowed to enter into the church? So you'll have to engage yourselves there. And of course, you'll have to see that in the light of the new norms. You would imagine that there are some priests who would not allow for a church funeral of somebody who has committed suicide. But in a sense, that belongs to the old law, because the new law sees suicide from a different perspective. Your moral theology would have understood suicide as something else. And that's why that has influenced our own understanding of who goes for church funeral and who is not allowed church funeral. So you'll have to see that for yourself as the canons would recommend. For example, there you are again, the church earnestly recommends that the pious custom of burial be retained. But the question of cremation has already come into the entire understanding of church funeral. Interment, that means burial, and inurnment, that means the ashes through an urn are inurned. So there are places for that, and the whole practice has already been acceptable in the church. And then veneration of saints, sacred images, and relics, and then you have vows. It's good to take note that, when you talk of vows, for instance, the way it is being defined in the Code of Canon Law and how that is differentiated with oaths or vows as a public vow, what does that mean? For example, the communities always think, or our seminarians always think, that when it is public vow, that is a vow said in public. But how the church would have defined public there is very different, because a public vow is vow that is received by a competent authority. So, or in the name of the competent authority, meaning delegated authority. And private vow does not presume any reception of that vow. So it's something like more a vow directly done before God, in the presence of public, in the presence of the Christian community. So that's how we have to make distinction between public and private vows. And then you have oaths there. And next to the sacraments and other acts of divine worship, you have sacred places. And what do you mean by sacred places? Those assigned to divine worship, or those assigned to the burial of the faithful, or those assigned to dedication or blessing, which the liturgical books have prescribed. So that's when you talk of a sacred place. When you talk of a church, what does that mean? The church means what? The sacred building intended for divine worship, to which the faithful have the right to access, or right of access, for the exercise, especially public exercise of divine worship, and how that is being differentiated from what you would call oratories or private chapels. So what do you mean by an oratory? You go to a seminary, you go to a convent of sisters, and you find there the word oratory. So that simply means a place, generic place, of course, by permission of the ordinary, set aside for divine worship, for the convenience of a community or group of faithful who assemble there. You might think of a religious community having a church and also having an oratory. So oratory where they fulfill divine worship as a private community of the faithful, or as an inclusive community of the faithful. So of course, when an oratory is given access to some of Christ's faithful, aside from those who reside there, consent of the competent authority has to be sought. And one of one of the discussions when it comes to private chapels would always enter into what the canon says, that a private chapel means what? A place by permission of the local ordinary set aside for divine worship for the convenience of one or more individuals. So that is like really the way it is, private chapel. And even the bishop, so the bishop who resides in the bishop's residence, he can set up for himself and for a community, a private chapel, which enjoy the same rights as an oratory. And then you have, of course, shrines, and you have how shrines are defined, differentiated from a parish church. So you would think of the shrine of Christ the King, the shrine meaning a church or other sacred place, which with the approval of the local ordinary, so local ordinary, that means the bishop of the place, is by reason of special devotion frequented by faithful, whom you call, of course, pilgrims. And a shrine can be described as a national shrine. So you have like the National Shrine of Our Lady of Mount Carmel in Quezon City, or the National Shrine of Saint Joseph in the Archdiocese of Cebu. But you have also the Diocesan Shrine of Saint Joseph in the Diocese of Cubao. So you have like shrines described as National Shrine, or shrine described as Diocesan Shrine. So things like that. And in all, distinctions, the statutes of the shrine are to be determined principally for its purpose. And who heads the shrine? You have the rector who heads the shrine.
I found this on the web.
Sorry. Something entered into my laptop. So anyway, so you have shrines, and then you have, of course, altars. And you will have to learn that yourself, because the dedication of an altar. So at the dedication of the church, you have also the dedication of an altar. So an altar or table in which the Eucharistic sacrifice is celebrated. And normally when you talk of an altar, many people, I think as it is stipulated in the Code of Canon Law, is to be fixed. So if it is so constructed, it has to be fixed. It's attached to the floor and therefore cannot be moved. It is termed movable if it can be removed. But generally, the preference would be like a fixed altar, especially for a church or for an oratory. And then you have cemeteries. I think, and the interesting thing here in the cemeteries is when you are in a town, there's what you call the Catholic cemetery, which is differentiated from a public cemetery. But of course, today you have memorial parks, and that goes for any person of any religious affiliation. But the interesting thing there is, of course, the distinction between what you would call a Catholic cemetery in that particular town or a public cemetery as indicated for by the civil or the local government unit. So that's the sanctifying office of the church: sacraments, other acts of divine worship, sacred places, and then you have what you call sacred times. That's where you make sense of feast days and days of penance. So feast days, the feast day begins with the Lord's Day, and all others that have to be observed by the faithful. And when you call a feast day, you have also there what is a holiday of obligation. So particular feast days which are important for all of Christ's faithful. Of course, you have Christmas, you have the Epiphany, the Ascension of Christ, the body and blood of Christ, which is otherwise known as the Corpus Christi. And you have January 1, the Solemnity of Mary, Mother of God, and then down to what would be the closest to this month, the Immaculate Conception. Then you go to other feasts of Our Lady, the Assumption, and so on. The Episcopal conferences here may, with approval of the Apostolic See, that means approval of Rome, can suppress certain holidays of obligation or can transfer them to a Sunday. And then you have days of penance. Days of penance, as it is indicated here, are of course what is obliged for by a divine law, in which all of Christ's faithful have to do penance, and then the practice of the particular celebration of the sacrament of reconciliation, and then other things like the law of abstinence and the law of fasting, as we have always indicated here. So those are what you would call the sanctifying office of the church. Now, Book 5, that's if you have the sanctifying office that pertains to the sanctifying grace there, you have, of course, the temporal office of the church. And the temporal office, as it is indicated, is temporal. You know, the regulation of the secular power to attain, to acquire, to attain, to administer, and to alienate temporal goods. So those four actions there: acquire, how to acquire, for example, properties, and then to retain them and to administer them. The last verb is alienate. Alienate, that's a technical word, but otherwise would mean like selling, the selling of temporal goods, all with the objective of regulation of divine worship, provision of fitting support for the clergy and other ministers, and the carrying out of the works of the church for sacred apostolate and charity, especially for those in need. When you talk of temporal goods, it's always at the service of these three: divine worship, sustenance of those who work for divine worship, and the carrying of works and apostolate in the church, but especially at the service of those in need. So that's why you have there four actions. Again, you have the acquisition, you have the administration, and you have the alienation. In between, of course, you have what pertains to retain these temporal goods. So from acquisition, you go to administration, and there are ordinary and extraordinary administration of goods. You take note of what I have placed there in your slide, Canon 280. Every juridical person is to have its own finance committee, at least made up of 2 counselors who are to assist in the performance of the administrator's duties. That is so particular to the new Code of Canon Law, that every juridical person has to have its finance committee. You will see that especially when you discuss Book 2, People of God, going to the hierarchical constitution of the church. The universal law of the church has regulated that, has stipulated that, the importance of a finance committee. The diocese, that is almost like what we can say in law mandatory to have a diocesan finance committee. And then you go down to the parish has to have its finance committee. You go to the religious institutes. So I think that really reveals to us what the church values here. And of course, when you talk of finances, you talk of accountability, you talk of transparency, or you talk of the generic financial responsibility. And then you go to the alienation of goods. The words are rather threatening here, because you have alienation of goods, threatening transactions, and leases. So of course, when you when you have these words, you're also like, in a sense, what does it mean to be threatened? What transactions have to be always taken in or according to the provisions of universal law and according to the provisions of diocesan particular laws. Maybe it's good to take note. I usually have it in my Code of Canon Law. There are certain provisions that you follow. For example, when a province has to sell a property, or a provincial government or a provincial council sells a property of that religious institute, for example, located in the Philippines, there is a provision, a special provision when it comes to alienation, when it comes to selling properties. Properties sold in the Philippines amounting to more than $100,000 need the permission of the Holy See, need the permission of the Vatican. So there are provisions for that. There are certain regulations for that in every country, of course, because that means that every country's value of property is indicated when it comes to what is expensive, or what is what is more expensive than would be in other countries. So closest example is what we have in the Philippines. We cannot sell properties here in excess of $100,000 without the permission of the Vatican or the Apostolic See. So you have other points in the temporal goods of the church, pious wills, pious trusts, pious foundations. They actually refer to what? Those that have the intentions of the faithful who give or who leave goods for certain causes. And you have terminologies there, as I indicated in your slide, inter vivos or mortis causa. So like, for example, Canon 1299, paragraph 2, it says there, arrangements of mortis causa in favor of the church. The formalities of civil law are to be observed. So mortis causa, for the cause of death. So for example, people are already thinking of putting up a foundation because of, or for the cause of the death of this particular philanthropist, a person who has always dedicated his life for the church. So the family wants to put up a foundation, and the foundation is for the service of the scholarship of certain poor but deserving students. So those things are even regulated or are even stipulated in the laws of the church. So continue to look into those terminologies, inter vivos, alive, and mortis causa, death, for the cause of death. I leave it to that, the temporal goods of the church, and then you go to Book 6, the sanctions in the church pertaining to penal law. Remember what we've discussed there in Book 1, very important example that I have given you, and that is Canon 9, laws concern matters of the future, not those of the past, unless provision is made in them for the latter by name. And one example there is, of course, or one principle there is, of course, law cannot be retroactive. But there's what you call the retroactivity of penal laws. So, and that is important in the whole introduction to what you have in Canon, in Book 6, the sanctions in the church. And what is that? Sanctions in the church. They are there because the church has its own inherent right to constrain with penal sanctions Christ's faithful who commit offenses. But that's almost like as the church would have stipulated it, or even civil law would have stipulated it, we will have to exhaust all means before we finally arrive at this particular sanction, or at this particular penalty, or at this particular punishment. So if there is a way to do it so that we don't arrive at that penalty, we should in fact exhaust it. And that's why penal sanctions of the church are divided into what you call medicinal penalties or censures, and expiatory penalties. Now, by way of introduction, what we would call medicinal penalties. What is that? What do you call medicinal penalties? So you have 1331, what you call a medicinal penalty. So everything that has to do with how you can reform the person, medicinal. And then you have the expiatory penalties, that which affect the offender for a certain reason and for a certain determined time or indeterminate period. So everything has to be seen here in terms of how the law would respect the person's right to express oneself. So there's what you call in law, there can be no penalty without due process of law. So take note of those things, because as I mentioned already, the sanction or the penalty or the punishment there is only comes out after we have exhausted all means to arrive at such particular penalty. So you have certain things that would cover for penalties in the church or sanctions in the church. So a brief introduction on penal law and penal precepts. That is in fact Canon 1313. If a law is changed after an offense has been committed, the law more favorable to the offender is to be applied. So that's basically what I mentioned there at the beginning in Book 1, the retroactivity of the law. If a law is changed after an offense has been committed, the law more favorable to the offender is to be applied. So easily understood is as, for example, you have somebody who is accused of simple theft, and simple theft would only allow for at the most a week of imprisonment. Now, for example, the tribunal or the court, or maybe the better way of saying it, for example, the Congress would stipulate a new law for the simple theft. There should be no imprisonment. And you have this person who was already imprisoned because of a simple theft. Immediately, up until that law is, or that consideration for no theft, immediately the person is released, because the law more favorable to the offender is to be applied. So that's in reference to the fact that if a latter law removes a law, or at least a penalty, the penalty immediately lapses. And you have subjects of penal sanctions. Again, that basic principle: no one can be punished for a commission of an external violation of a law or precept unless there is grave imputable reason of culpability. So again, those basic principles have to be put here when you look at the subjects of penal sanctions, and you will have that when you enter into a more detailed penal process. And then the third element that I have put there in your slide when it comes to sanctions in the church are, of course, penalties and other punishments. I highlighted one point there, ferende sententiae, which you find very much in many court proceedings, and what you have also late sententiae. So ferende sententiae means it's binding once it is imposed. But you have the late sententiae, that means automatic. So late sententiae, so automatic imposition of that particular penalty by virtue of the fact that this person has committed this. So late sententiae and ferende sententiae. And there are many elements there. Censures, which what I mentioned, medicinal, expiatory, which has something to do with atonement, and then penal remedies, preventive, and then penances, which are substitutive. Very technical terminologies here, but everything is indicated for in the Code of Canon Law. After you have penalties and other punishments, then you have, of course, the application of penalties, and then the cessation of penalties. What you call cessation is cease. When does it cease? When does it stop? When is a person released from prison, as it is in the civil code? Or when do we stop? When does a person, released from such a penalty, from such imposition of a precept? For example, a priest is suspended. So when is he released from particular suspension? Everything is in that code. And then you have, of course, the penalties for individual delicts, penalties for individual violations, and then the penal process. The penal process generically has 3 steps. Preliminary investigation. That is very important when you, for example, enter into when do we arrive at a particular suspension. So you can never arrive at that suspension when there is no preliminary investigation. So you go by investigating everything that has to do with that particular case. Investigating means you even enter into interviewing particular persons. Before you practically arrive at any suspension, there is a preliminary investigation. And then you have the development of the judicial and extrajudicial processes. So you have judicial processes, that means, of course, through a tribunal, and the extrajudicial processes outside what you call the tribunal. And then the third is, of course, action to repair damages. Maybe something to share where I got involved in this suspension of a priest over a sexual misconduct, which is a very sensitive penal process in the church, what you would call administrative procedures that would lead to the suspension of a priest, or maybe not just suspension of a priest, but at the end of the day, a priest who is a priest forever in the order of Melchizedek finally is released from the obligation of the priestly ministry. So you have really preliminary investigation, which is, again, very tedious work. I remember when we investigated this particular case, we had to trace every step of this priest, because you go by the detailed process. For example, if the accused would say that I have been taken to this convent and abused in the sacristy, which sometimes you would not even imagine, but if there is something like a detailed statement on that, or a detailed statement of fact, on that particular case, we had to go to this church and look into the sacristy. How could that have happened? And where could they have passed? Or the accused would say, I used to be taken by this priest to for an ice cream after we would play ping pong. And so we had to go to that place where they play ping pong at the garage of the rectory and where that ice cream bar is located. Or the accused would say, a priest after he treats me for a bar for an ice cream would take me to his home. So we would have to look into that, where that house is located. So a very tedious work because it's by the details, and that's preliminary investigation before you finally go into the development of the judicial process. So when a tribunal is composed, and now everything goes to the Vatican, and the Vatican will have to establish the decree of the development of a tribunal, where usually the decree is, or the tribunal is passed on to that particular local church. So let the archdiocese establish the tribunal of 3 judges. This decree has to come from the Vatican to the Sacred Congregation of the Doctrine of the Faith. So those elements. And then finally, you have action or a sentence. What does that mean? Make a conclusion and arrive at a sentence. Action to repair damages. I was reading this particular case, and interestingly, it fell on the wrong accused person. And you would imagine that there is a priest being investigated for this particular case, and at the end, it fell on him wrongly. So when you say action to repair damages, you have to make sure that the tribunal establishes a decree, and through that decree, we'll have also to establish a statement where you have to repair the damage being done. Because in the meantime, at the preliminary investigation, you must have damaged the person. So for that reason, you'll have to restore the reputation of the person at the beginning. Meaning restore the reputation, restore the good reputation there is in every person. So that is the penal process. So you have those sanctions in the church, and then you go to the book on processes, which is actually the last book of the Code of Canon Law. So you go by the Book 1, General Norms, which is actually the content of your course here in Canon Law 1, and then Book 2, which is People of God, which is practically the content of the course of Canon Law 2. Of course, some institutions would take that in Canon Law 1 and enter into the sanctifying office of the church and all there is that pertains to the sacraments in Canon Law 2, and then Canon Law 3, which is particular to the marriage processes. So you have Book 2 and then Book 3, which pertains to what we've said, the teaching office of the church. Book 4, the sanctifying office of the church. Book 5, the temporal goods of the church. Book 6, which is the sanctions in the church. And then Book 7, processes. And a very important book, because that is what pertains to persons. You have persons and processes. Another word for that book is, of course, procedures. I indicated there in your slide on processes, all there is that has to do with process, trials in general, the competent forum. When you say competent forum, has the establishing the competency of the case, or the competence of the persons involved in the tribunal. So who has competence in this? Who can investigate the whole thing? And then you have the different grades and kinds of tribunals. So in civil law, you easily call that the court of first instance, the court of second instance, and then you have the Court of Appeals or the Appellate Court before it finally reaches the Supreme Court. We have also something like that in the church. And in the Philippines, we have, for example, particular to the Philippines, the Vatican has allowed us to maintain what you call the National Appellate Court, which was actually taking care of marriage cases. So what could not be decided in the first court or in the court of first instance, which is the tribunal, goes to the appellate court before it is finally turned over to the Supreme Court, or what you would call there the judicial court in the Vatican. Now maybe a note on that, and I placed that there in the slide. When you go to the different grades and kinds of tribunal, you have the first instance, second instance, and the tribunals of the Apostolic See. Note on that. What is a note on that? There is, Pope Francis has established in 2 apostolic constitutions, or in 2 apostolic letters, the tribunal for marriage annulment. And maybe it's good to read these apostolic letters for you. One of the apostolic letters is the gentle judge, the Lord Jesus, and another apostolic letter is the meek and merciful Jesus, both in reference to his reforms of the tribunal for marriage annulment. And what is that? Pope Francis, through these apostolic letters, has eliminated a requirement that all annulment decisions get a second judgment. So remember what I told you, from the court of first instance, which happens in the diocese or in the archdiocese, it goes to the National Appellate Court. Now, practically, by the 2 apostolic, or through the 2 apostolic letters, he has eliminated the requirement that all annulment decisions pass to a second judgment, meaning all couples seeking annulment will have to obtain only one sentence from one single tribunal, and that single tribunal will come from the diocese. In other words, it also goes with, it goes to say that the moral certainty reached by the first judge should be sufficient. In other words, the moral certainty reached in the diocesan tribunal should be sufficient. It does not have to go through a second judge. It does not have to go through an appellate court. So the tribunal for marriage annulment in the reform of Pope Francis allows all bishops, all local ordinaries, to be particular, to expedite annulment processes. I even take note of the special consideration there, free of charge. Because people always thought that it is very costly to go for a marriage annulment. And the Pope has emphasized that all bishops or local ordinaries have to expedite, that means expedite, to speed up annulment process, and free of charge. So altogether, in what you call here the different grades and kinds of tribunal in the tribunal for marriage annulment, the Pope has expanded the role of local bishops in judging nullification proceedings. And that means it can only but happen in one single tribunal, which is in the diocese. And I suppose it's a way of putting emphasis on human rights, or the rights of the persons to get speedy judgment over a particular case. And this particular case is in reference to marriage. So that's all for the tribunal for marriage annulment, which is a new law here. And then there's what you call in the processes, discipline to be observed in tribunals. Interestingly, if you would study canon law and you would be considered in the tribunal of the diocese, you would go you will have to attain what you call discipline to be observed in tribunal. So duties of judges and tribunal ministers, aside from the three judges, before this were limited to priest canon lawyers, and now you have, of course, many lay canon lawyers. I'm not very familiar here in the Philippines, but when you go to the Vatican, you will realize that they have experts. They have lay canon lawyers. They're canon lawyers from among the lay people who really study law itself, the laws of the church. So, and tribunal ministers would be like the defender of the bond, who is a very important personality in the tribunal. And then you have, of course, the notary, who is in the person of somebody who take notes, or the secretary of the tribunal, and the order of adjudication. This is like when you are in a tribunal process, you have to be a very patient person there, because the order of adjudication is by way of order. I mean, putting things orderly, like how it is. You don't presume that the person knows this. So everything has to be, for example, ask the queries that have to be asked at the beginning. So state your name, state your address, so all those things. You follow an order of adjudication. And then, of course, adjudication here means, in the final analysis, judgment. So the order that you have to follow when it comes to arriving at the sentence. And then you have time limits and delays. So remember that if one has to speak of human rights, it is like post office. Do not delay. And I think Pope Francis has put everything in a way, in a professional and more competent level when it comes to the tribunal for marriage. So you have their trials in general, the competent forum, the different grades and kinds of tribunal, the discipline to be observed in tribunals, and then you have parties in a case. So you would know that there is somebody who files the case, and then there is a respondent to the case. What the person who files the case would do is also what the court would provide the one who has to respond to the case. So parties in a case. You have, of course, witnesses to the case. So when you have summoned the respondent, of course, you're also going to summon witnesses to a case. Our tribunals really make sure that we will arrive at a moral certainty to a case in question. So, for example, there has been a debate over 3 witnesses. Would that suffice, or should we get into 5? So the feeling of many tribunals in the church would always be like, let's get as many more witnesses as there is, because we want to arrive at what you call the moral certainty of the question or the case itself. So 5 to 7 witnesses. Again, that's a very tedious task in a tribunal, but we want to, as much as possible, arrive at moral certainty. And then you have actions and exceptions, and then the oral contentious process. I always say that what differentiates church tribunal, marriage tribunal, from a civil marriage tribunal. In the church marriage tribunal, everything is taken on what is written. So we actually rely on narratives. So it's different when you go for the civil marriage tribunal, because there is it's an oral process. There is more debate. There is more well, I should not say debate, but there is more interpellation, interrogation and interpellation. But in the church marriage tribunal, we rely a whole lot on what is written, and then on the narratives. So in fact, when you file for a marriage annulment, you have to write everything. So which is very important, and that's what the tribunal of judges study. And from there, that's where we will have to ascertain things through the witnesses, which is, of course, different from an oral process. And yet, of course, in the processes indicated for in the church, we have oral contentious process, and what that means. So you have that in the Code of Canon Law. So that concludes the entire code by way of giving you some bits of introductory remarks to the different books. Now, I want to conclude the course itself by the following points. By way of conclusion to Book 1, I place there the most fundamental doctrine regarding canon law is the notion that it is not a foreign or it is not an extraneous aspect of the church. It is a development that has imposed itself on the church with the passage of time, with the multiplication of human problems. In other words, we go back to what we said there, the very basic principle of law. Law follows life. Precisely why we have laws in church. We have laws in the life of every living organism. And so canon law becomes a constitutive element of the church. It is a constitutive element of the church in her original conception according to the will of Christ. Now, if you have to go to sacred scriptures, as we have done in this course, we looked at the sources of the code, which is sacred scriptures. Now, one of the things that you realize there is the Exodus of Israel. The Exodus of Israel in the Old Testament has been accompanied by legislation. Come to think of the Lord or Yahweh teaching them the way of righteousness. So the journey to the promised land was accompanied by legislation. Christ did not come to abolish the law, as what we've mentioned there in the Gospel of Matthew, chapter 5, verse 17. Christ did not come to abolish the law, but to fulfill it. And that reveals the deeper significance of the Decalogue. So from the Old Testament to the New Testament, Christ, or Jesus the Jew, speaking as a Jew, how important the law is for them. But of course, he speaks of it in a new way, fulfilling the old law. And I've exhausted that reflection in the way of looking at how sacred scriptures has in fact influenced the code of canon law. Christ proclaimed the law of love. That's another thing. The Lex Christi, as emphasized very much by St. Paul in the letters of Paul, but especially in the letter of Paul to the Galatians. If you want the particular verse, I put it there, chapter 6, verse 2. The Lex Christi, the law of love, the law of Christ, which is actually the law of love. The original apostolic power given by Christ was extended to his successors in the form of ecclesiastical power. Again, that's one of the reflections when we look at the law as constitutive to the church. The original apostolic power given by Christ extended to his successors in the form of ecclesiastical power. So in order to demonstrate the intrinsic canon law, how intrinsic rather canon law is in the life of the church, and how essentially connected it is with the magisterium and the deposit of faith, we we look at it from the illustration of Pope John Paul II. He illustrated you have there the laws and how that is influenced by sacred scriptures, the magisterium, the juridical patrimony, and then the documents of Vatican II, and finally you have the code. So, it actually brings you to how complex the laws of the church is. We just don't talk here of canon law, the code of canon law, but we also talk of it's being influenced by the documents of Vatican II. It's being influenced by the juridical patrimony, what has been passed on already in the laws of the church. And then how influenced that is by the magisterial teachings, and how, of course, sacred scriptures, or what place sacred scriptures has or there is in the laws of the church. So a few more points. There is therefore an intrinsic connection between the juridical norms with the doctrine of the church. The latter necessitates the former. So the doctrine of the church necessitates the juridical norms of the church, while the former, the juridical norms, reflects and draws its meaning from the doctrines of the church. So that is important. As the council insisted, the law of the church should be an instrument of her spiritual life. It rejects, therefore, a separation between the spirit and the law. And if you have one of the commentaries of the Code of Canon Law, for example, the commentary of the Canon Law Society of Australia and Wales, you have what you call their letter and spirit, and I think that the title speaks for itself. Between the so-called spiritual church and the church of an institutional character. Third point is, I emphasize the fact that the polarity between the spiritual character of the church and the juridical character from the church, far from becoming a source of tension, is always oriented toward the good of the church, which is interiorly animated and exteriorly sealed by the Spirit. The last canon in the Code of Canon Law of 1983 speaks about that. Canon 1752. What is the supreme law of the church? It is the salvation of souls. Because Christ is the Savior of humankind, the church law, therefore, can also be described as directed unilaterally toward the Christian as a human person. The essence of canon law is the person of the Christian in the church. Don't forget that. I've made mention of that when we talk about use. There is the objective sense of the law, and there is the subjective sense of the law. The essence of canon law is the person of the Christian in the church. Didn't I not say it? Behind every law is a subject. Behind every law is a person. Behind every law is a community of the faithful. So, again, by way of conclusion, what is the pastoral nature of the Code of Canon Law? It is necessary to affirm the intrinsic pastoral character of the Code. By its nature, canon law is pastoral. And that is important. In your exercise for the final exam, you'll have to indicate the concept itself, and how that is stipulated for, or what are the stipulations of the concept in the code. And of course, you'll have to set examples of it by way of how this concept is interpreted according to the spirit of the code. The code is pastoral. The term pastoral means nothing else but the salvific service of the church, which is based on the salvific will of God. I make sense of this when, for example, I send people for apostolate, or seminarians go for apostolate. Of course, when you come back, you give a report of what you've done there or what you've not done there. But equally important is not just the service aspect, the formative aspect. What has this done to you? Or what happened to you in the apostolate? So the service has to come with a formative aspect. It is an expression, an instrument of the munus apostolicum. Munus apostolicum. The salvific mission of the church, or the salvific mission of Christ the Good Shepherd, entrusted to the apostles and its leaders. That's the pastoral nature of the code. Christ wills that his church be characterized by internal relationships of justice. Internal relationships of justice. This intra-ecclesial justice naturally fosters the extra work of charity which Christ has entrusted to the church. So there you are again. Talk of what has happened to you. St. Vincent School of Theology. Vincent helps. At the end of the day, you feel like we cannot just sit down here, or we cannot just pray over here when we think of what's happening around us, when we think of the victims of a typhoon. We'll have to do something. And I must say, I have always capitalized the fact that I'm impressed by Vincent Helps. So that's what I call there. Christ wills that his church is characterized by internal relationships of justice. And when you give, we also ask why there is so little. So when you give to the poor, you also ask why there are poor people. All law in the church, or maybe you can say also all laws in the church, have truth and charity as its constitutive elements and its primary motivating principles. So think about truth and charity. Last point, marks of the canonical system. So what are the markers for the code of canon law, the church law? Canon law is sacred. It's vivified by the Spirit and attributes the principal place of love, grace, and charism. Did I not say that when we talked about the way St. Paul would put the laws or put significance to the law? So it cannot be a replacement to love. It cannot replace grace. It cannot replace charism. And yet we will have to say that canon law is sacred. Canon law is marked by notable humanitas and Christian equity. It supports the dignity and the fundamental rights of the human person and the whole of creation. The canonical system is animated and sustained by unity and vastness, by liberty and discipline. So you always have to think, for instance, the word today is like, you have to understand things outside the box. So that is to bring us to the aspect of, you have to see the wider horizon of life, or you will have to see the situation of life, which is when you look at the case, for example, you'll have to begin you have to begin in what you also begin in scriptures, the Sitz im Leben, the situation of life, the background of the person. So the canonical system is animated and sustained by unity and vastness, liberty and discipline, the unity of religious discipline with a variety of prescriptions. So there is not just but one mold, there are many molds. There is not just but one framework, there are many frameworks. A unified body of the human curia with a vast array of subject matter and internal norms extending to the various offices. And amazingly, when you talk of, for example, curia, curare, to take care of, of the discipline there is in the church, you also see how these offices have developed. For example, the Pope has put together many offices there and has come up with the office that promotes integral human development. Marks of canonical system or the markers of church law, I also place it there. It is hierarchical. That's undeniable. It is based on the supreme authority of the Roman Pontiff and the College of Bishops. It is based on the authority of the college of the local ordinary, together with his presbyterium, the priests, and of course, the Council of Priests and the College of Consultors. It goes by what you have in the Institutes of Consecrated Life and Societies of Apostolic Life. The superior has to act with his council, whether that is with the consent of his council or that is in consultation with the council, but the superior has to have a council. Marks of the canonical system, I place it there. It should create bonds of communion. Very important. And it is missionary. When I say missionary, it strives to facilitate the church ad extra orientation. Canon 1752, the last canon, the supreme law of the church. We seek to achieve the ultimate end, meaning penalties are imposed to repair or prevent scandal. That's what I mentioned there in the Sanctions of the Church, Book 6. But this is sought ultimately in order to win the repentance of the offender. That is important. Penalties are imposed to repair or prevent scandal, but this is sought ultimately in order to win the repentance of the offender. Ecclesiastical authorities are established so that good order may be better assured, and all are guaranteed the pastoral care of the church. So, for example, you have in your church that should be well published, that should be at the information of everyone, what services you give in your parish. So I like to see, that very well indicated in the bulletin of the parishes, in the big board of the parishes, schedules of services of the sacraments, and of course, when you announce something there, with what pertains to other services aside from the sacraments, they are equally important. And of course, liturgical laws are issued in order to promote the order and beauty of the sacred liturgy. Overall purpose of canon law is meant significantly to influence the lives of Christ's faithful who should know it and follow it. It is intended to promote the tranquil and ordered progression of the social life of the people of God. It is intended to be, above all, a norm which principally intends to interpret the twofold law, the superior one, which is the divine one, and the interior one, which is the moral law, the law of conscience. The Latin axiom there, you'll have to know that very well, lex orandi, lex credendi in liturgical law. Lex agendi, lex credendi. So the law of prayer is the law of belief. Of course, the law of action is the law of belief. That should end our presentation, our reflection on Book 1, which is the course on Canon Law 1. Now then I will give you your assignments. There is a concept you have to develop by way of preliminary investigation, observation of the concept. How do you understand that? What canon law has to say about it, and of course how that is being applied. In the application, that's where you express the spirit of this particular concept or the spirit of the law. So that brings you to the letter and spirit. Thank you, and hope to see you next meeting for the presentations.